from the AG's offices to come speak with us because they're a really important part of the regulatory scheme and work very closely with the FTC and FCC, and then of course have their own enforcement actions that they're working on. There are 50 different state attorneys general. While they do have a lot of issues that overlap and a lot of issues that they cooperate on, each state also has their own individual issues that are of importance, and we'll be talking about those types of things now. Have questions ready. They have graciously agreed to ask questions at the end, so write those down and think about those as we're going through the presentation. We'll hold questions until the end. And with that, I'm going to bring Boris on stage from Livebox, who's going to do introductions.
Absolutely. Thank you, Michele, for the introduction. Just to introduce you to Livebox that we have in part of our platform. We are the largest pure cloud contact center solution in the market space, facilitating over 9 billion interactions on a yearly basis. The platform has won 4 TCPA court rulings and has really sort of heavily invested in compliance solutions for our clients. We provide both outbound, inbound, email, SMS, as well as other multi-channel interactions on our platform. So with that, I would like to introduce the folks that have kindly joined us here on the panel today. Blake B. is Program Counsel of the newly established NAGTRI, Center for Consumer Protection. The center is the nation's only entity solely dedicated to provide training, research, expertise, and other resources to the staff of attorney general offices and other government attorneys and staff committed to protecting the public against consumer fraud and abuse. In addition to that, we're joined by Philip Ziperman. He is the Director of DC Attorney General Carl Racine's Office of Consumer Protection. As the Director, Philip oversees the legislative, consumer education, and enforcement activities of the Office of Consumer Protection. Philip has led national efforts to reform the debt elite and debt collection industries. Formerly, Philip served as the Deputy Chief of the Maryland Attorney General's Consumer Protection Division. Philip also managed the Maryland Attorney General's Privacy Unit, which monitored compliance with state and federal privacy and consumer protection laws, investigated businesses that failed to protect consumers' personal information, and educated the public on privacy matters. And of course, we're joined here by Michele Shuster, who does not need an introduction. And with that, I turn it over to you folks.
I guess we should also add that Phil is, we're very thankful that he's here today because he is leading the investigation into the Experian data breach. So, I'm sorry. So this is a breaking news, there's a new one. Equifax data breach. So he's been very busy lately. So.
Great, and okay, it's on. Good. My name is Blake B. I appreciate Boris for the introduction. I'm going to talk to you a little bit about the National Association of Attorneys General, or NAG, as I will refer to it throughout the presentation. It's going to be very basic, but first, I'm from Mississippi. You couldn't tell by my accent. And in the middle there is Attorney General Jim Hood. He has been Attorney General since 2004. I'm brand new to DC and moved to DC on June 4th of this year to work for NAG. I left the Attorney General's office in Mississippi after 8.5 years. I hated to leave AG Hood, but this was a good opportunity, and NAG provided me with an offer I couldn't refuse because they're such good people. So now, as a DC resident, I live in the district, which is what we call DC up here, and the Attorney General, right, and the Attorney General for the District of Columbia is this man right here, AG Attorney General Carl Racine. A very good man, good person, and great lawyer. So, now that I've shown you a couple pictures of Attorneys General, let me tell you a little bit about what they are and what they do. What they do, their legal authority actually depends on whatever state they're in. But typically, they're the chief legal officer of the state, commonwealth, or territory of the U.S. They're the state's lawyer. The state, not the people, it's the state entity. They serve as counselors to state governments, so they represent legislatures, state agencies, and they control all the litigation that goes on in a state on behalf of the state. And in certain states, they have criminal authority. They can investigate crimes. For example, in Mississippi Attorney General's office was responsible for prosecuting child exploitation, child pornography type cases. But where you are most familiar with attorneys general, if you've seen them in the news, it's going to be in their public advocacy. So, is there anyone here from Arizona? All right, okay. Well, your Arizona AG is Mark Grinovich, and here's an example of him acting as a public advocate, warning about the dangers we as consumers face online. So if you could please roll that.
I'm Attorney General Mark Grinovich. Nowadays, we all have to worry about cybersecurity. Hackers are looking for new ways to break into our computers, and something as simple as visiting a pirate website can put your computer at risk. Hackers use pirate websites to infect your computer, steal your identity and financial information. They can take over your computer's camera without you even knowing about it. Don't let hackers into your house. Be careful with the websites you visit, and warn your kids to stay safe online. To learn more, visit my website.
So, that's a PSA, I'm sorry, that's a PSA that we typically see Attorney General make. Now, is there anyone here from Wisconsin? Nobody? It's all right. Well, here's an example of Attorney General Brad Schimel, who's the Attorney General of Wisconsin, talking about the awful opioid epidemic we have going on right now. So please roll that video.
Hello, I'm Attorney General Brad Schimel. Since last year, I have been sharing the dose of reality message with you on your TV, on your computer, and in your doctor's office. We've gotten a lot of attention on the dose of reality spots with the trademark pill bottle bearing the skull and crossbones. We've been sharing the challenges posed by the heroin and prescription narcotic painkiller epidemic sweeping our state. We've shared news of drug take-back days and the successful collection from the fall when a record 44,698 pounds of drugs were collected. Most important, your feedback tells me we even shocked you. That was the point. Now I'm here to share another dose of reality with you. Heroin and prescription narcotic painkiller abuse costs U.S. employers about $26 billion a year. 4 out of 5 employers have had to deal with opioid prescription addiction and abuse in their workplace. Here is the latest dose of reality. The impact this addiction is having on our economy means that it is vital that the Wisconsin Department of Justice partner with the business community. This is the next phase of the dose of reality in Wisconsin. We are providing materials for employers to share in the workplace to help aid in early intervention, including spotting the signs of abuse and the dangers of using prescription narcotic painkillers at work. I have said sharing this message is the most important thing I will do as Attorney General because I believe it will save lives. Please check out the information on this new effort at www.doseofrealitywi.gov. And thank you for joining me in this fight.
Okay, those were 2 examples of attorneys general engaging the public directly. But, not too quick. How do attorneys general offices work? Well, typically they're broken down into divisions. For example, you have the Consumer Protection Division, and this division prosecutes cases of unfair or deceptive business practices and untrue or misleading advertising. For example, several years ago, actress Jamie Lee Curtis starred in a yogurt commercial. Does anyone remember that? Activia, and she said this yogurt, she looked phenomenal, and this yogurt's going to help our digestive system. Well, it turns out that those claims were not supported by any scientific or medical evidence, and the manufacturer of that yogurt then settled, paid $20 million to 38 states to settle that allegation. So that is the type of case a Consumer Protection Division would be a part of at an Attorney General office. Civil litigation, this is the one when I talked earlier about the AG being the state's lawyer. An example of how the Civil Litigation Division would work, let's say state policeman is involved in a chase, is chasing an individual, and the state policeman in his car rams another car that's not related to the chase. And that the driver of that car sues the state, sues that policeman. The Attorney General will step in and represent that police officer in court. Criminal litigation, and this is different in each state. Some states give the Attorney General the authority to prosecute cases criminally, like a district attorney, for example. The state of Rhode Island does not have district attorneys. The Attorney General in Rhode Island handles all criminal prosecution for that state. Now, many states have district attorneys, but in certain states, the AG can step in when there's a conflict with the district attorney. In Mississippi, for example, if a district attorney is prosecuting a friend of his and says, I need to be conflicted out, I can't ethically do my duty because I know this person, so then the Attorney General's office will step in and try the case. That's for litigation. In other situations, as I mentioned, the Mississippi Cybercrime Unit, the Attorney General's office is the sole entity that will go after child exploitation, child pornography. Also, public corruption cases against elected officials. That's another criminal public corruption. That is another area where the state Attorney General may step in. State agencies, this is like your State Department of Transportation. If they're about to build a massive highway, the State Attorney General will have lawyers representing that agency and making sure that they meet all the regulatory requirements the federal government has for building a road. So that would be an example of a state agency representation within an Attorney General's office. Legal opinions, in many states, the Attorney General is the official interpreter of state law. So for example, the legislature passes a law that is unclear. An elected official, a state elected official, or agency can request the Attorney General to give them an opinion saying, hey, what did the legislature do? What does this mean? So that would be an example. That's kind of a breakdown of some basics in the Attorney General's office. Now, does anyone know who this is?
Attorney General.
Right, but anyone from New Jersey? All right, New Jersey, okay. This is current Attorney General Christopher Perino. Now, I've talked to you about some public advocacy that the Attorney General do. I've talked about what an Attorney General does, his legal responsibilities, but how do you become an Attorney General? Well, in New Jersey, the Attorney General is appointed by the governor. And this fall, New Jersey will be electing its governor. So if you're from New Jersey, when you vote for governor, you will also directly be voting for the person who will choose your Attorney General. Now, does anyone know who this is? You don't have. Anyone from Virginia? There you go, Mark Herring, that's correct. Attorney General Mark Herring. He is running for re-election. Virginia elects its Attorney General. So this November 7th, if you live in Virginia, you'll be able to vote for him or against him, however you choose. Now, what about the rest of the nation? Electing the Attorney General is by far the most popular method. 43 states, including territories and other jurisdictions, elect its Attorneys General. It is appointed by the governor in 5 states, Alaska, Hawaii, New Hampshire, New Jersey, and Wyoming, and in the 3 jurisdictions of American Samoa, Puerto Rico, and the Virgin Islands. 2 states are quirky in their own good way. In Maine, it's selected by the state legislature. The legislature holds a secret ballot election and appoints the Attorney General, or elects the Attorney General. Tennessee is selected by the state Supreme Court. Now, back to NAG, the National Association of Attorneys General. NAG is a professional association, just like PACE. We're based in Washington, D.C. Unlike other professional associations, we are not an advocacy organization. We do not lobby Congress, we do not lobby state legislators one way or the other. We are strictly a professional association that also has a training and research arm, which I will get to in a moment. Membership, all 50 states, we have 56 members, all 50 states, the District of Columbia, and our territories and other jurisdictions are members of NAG. Does So if you want to know who your Attorney General is, and I'll quiz you a little bit about that, please just visit us at www.nag.org, and you can find out. Now, I talked about NAG as a professional association. It also has a training and research arm called NAG-TREE, which stands for the National Attorneys General Training and Research Institute. Now, this organization trains Attorneys General office staff on various topics. Here are 4 big ones. Trial advocacy. We will go around the country and train state attorneys and assistant attorneys general how to try a case, some of the basics. And we will even train seasoned trial lawyers to hone their skills. Legal writing, we'll teach them how to write a brief, how to make sure they have the best citations, negotiation skills. We will make sure that our attorneys, our assistant attorneys general, can have the best ability to negotiate on behalf of their state and on behalf of the people in that state. And as is sadly a running theme at some of my presentations, overdose death investigation. We actually have a course on that now because of the opioid epidemic that General Schimmel mentioned in his PSA. Now for myself, NAG has several special legalized centers, one of which I work for, and that's the Center for Consumer Protection. And it provides technical assistance and support to consumer protection divisions within the Attorney General's office. So this is the division that went after Dannon for its Jamie Lee Curtis ad. So that's the entity within NAG that I work for. Now, I want to leave you with a scam, because one of the things the Attorneys General do is try to prevent scams and protect people from them and educate them to make sure they avoid getting caught by scamsters. So this is, and I know you can't see it very well, but this is what's called a tech support scam. Is anyone familiar with a tech support scam? Good. That's great. So for those that are not, I will walk you through the slide. I know it's hard to read, but typically you will get a pop-up message on your computer warning that the computer is infected. The message will provide a toll-free number for you to call, and many consumers are obviously frightened by the message and will make the phone call. They'll be then connected to a call center where the person answering the phone pretends to be a technician. And oftentimes they're going to pretend to be one affiliated with a company that you trust, such as this one here is Microsoft, obviously this is fake Microsoft, or Apple. And at that point, the consumer will be given directions from this technician, who's really just a sales agent, to give them remote access to their computer so that the technician can run a free diagnostic test. Well, as the sales agent / technician runs the consumer through this fake diagnostic test, the test inevitably will show that your computer is infected, and to remove that infection, you need to pay, name your price, $50. Oftentimes, it will not be a one-time fee. It will be $50, and they'll charge your credit card a monthly fee of $50, for example. And it's very hard to get those charges taken off once they're added. We see this scam particularly affecting our elderly community, and so it's one to be very wary of. First of all, never give your remote access to your computer to anyone at all. There's no reason for you to do it. Microsoft, Apple, they're not going to ask for it, so that should be warning number one. Number two, these are just ads. When you're at your computer, you'll get pop-ups all the time, and they will inevitably say, "This is your computer's infected. There's an issue." That's an ad. Just close it. Nothing's wrong with your computer. So, now, we were talking earlier about how you as an organization can interact more with your attorneys general. One area that I think is key is the consumer protection divisions of of the AG offices. And a good way to meet them is to attend one of our annual conferences. We have 2 each year. This upcoming one is October 23rd in St. Petersburg, Florida. There is a public day, and that public day will include sessions on ransomware, do not call lists, children's issues, and anti-disparagement clauses. There is a fee to register, but there is a day that's open to the public. If you can't make it this October in Florida, we will have a regular conference in Washington, D.C. in February. And then also will include a public day. So that's me, and I'll turn it over to Phil in a moment. This is my contact information, but I do have some NAG swag that I can give out that I want to collect about some of you, including a cell phone portable charger that you ever get lost in the airport when there are no outlets. We got you covered. So I'm just curious, who traveled the furthest? Is there anyone from Alaska? Hawaii? All right, congratulations. I will come on.
That's what you said?
And I will be happy to answer any questions when we get to that portion of the panel.
So I'll try and be quick because I want to make sure we have time for questions, but my name is Phil Ziperman. I'm the director of General Carl Racine's Office of Consumer Protection here in the district. The District of Columbia is not a state, although if we were, it would be bigger than Vermont and Wyoming, and we're actually getting caught up on a couple of Dakotas. So it's a pretty large jurisdiction. The Attorney General's office here traditionally functioned more like a city solicitor's office, and so we were the mayor's counsel when people hit, DC cars hit people or people hit things in DC. We would take care of defending those cases. We do child support, all of that stuff. But when General Racine became DC's first elected Attorney General, he decided to take the office and turn it into more of a traditional AG's office, much the same way that Blake has just described. And so about a year and a half ago, we set up our Office of Consumer Protection. I'm going to talk to you a little bit about that office, what we do with other states, so you've got a better idea of how either complaints of consumers or enforcement matters land on our desk. So if I work this thing correctly, great. This is what we do. We mediate complaints. We get several thousand each year. We have mediators that will talk to the business, exchange letters, and try and resolve them. Those complaints are also a source of some of the enforcement actions we bring. If we see a pattern of complaints against a particular business locally, and I'm going to show you an ad from one of them in a couple of minutes, we can start an enforcement action, which is the second thing we do. We bring these cases both locally. Right now we're involved in litigating a case on an individual local scale with a company that was taking rent-controlled housing and operating illegal Airbnb. They were also charging sales taxes but not turning it over to the city. We've got a national case that we're also litigating involving the Marriott hotel chain. We're concerned about resort fees that they're charging, but they don't disclose either until you check into the hotel or it's there on the reservation site, but you have to be a bit of a detective to go find it. We draft and support consumer-facing legislation, and that's both locally and on a national scale. And we do public outreach, much similar to what you just seen from Blake, but in our office we sort of do it ourselves, and so it's not nearly as nice as the one you saw from Arizona. All right. This is the types of relief we can get. We can issue injunctions, either requiring businesses to do things or requiring them to stop doing things, which is mandatory and prohibitory injunctions. We can get restitution for consumers. We can penalize businesses up to $1,000 for a violation. And a violation would be every time a business makes a misrepresentation. So every time an ad runs and a consumer is misled by it, that transaction would trigger a penalty, and then we get costs and attorney's fees. So we get cases from a lot of different places, and I'm not going to leave that up for very long, but it's federal agencies, local agencies, complaints, nonprofits, they just come from all over. And we do lots of different things. Telemarketing's in there somewhere. I can't read it from over here, but there's a whole variety of different subject areas. So what is an unfair and deceptive trade practice? Every state's got a similar Consumer Protection Act. The laws are not that different or varied when it comes to state Consumer Protection Acts, and most state Consumer Protection Acts can really boil down to three types of violations. Either you make a statement, an affirmative statement that's capable of misleading the consumer, or you fail to tell them something that they need to know in order to decide whether or not to make their purchase. That would be a material omission. And then the third theory, which actually doesn't currently exist under DC's law, but we're working on it, is a practice that's unfair. It's a practice that causes substantial harm to a consumer that a consumer can't reasonably avoid, and there's no benefit to the marketplace. That's it, one slide, and that covers about 75 years of jurisprudence in about 56 jurisdictions. I don't mean this to sound too ominous, but one thing that business should be aware of is this: individuals can be held liable for consumer protection violations, not through traditional theories of piercing a corporate veil, but if an individual of a company participates in unfair deceptive trade practices, then they can be held responsible. And I'm going to pause for a minute, actually, to say something that I really had meant to say up front. I'm not here today as an adversary. One of the things that I know my boss would say if he was here, and I think is worth repeating, we're on the same side of a lot of these cases. State AGs function like prosecutors. We get lots and lots and lots of complaints. And so when we investigate an individual case, either locally or with other AGs, generally speaking, you're talking about a practice that's the worst of the worst. I mean, Lord knows there's plenty of problems that exist here in the city, and we don't have the staff to prosecute every complaint that lands on our desk. So we're looking at things that are pretty serious, pretty impactful. And so generally speaking, you're talking about the people that are on the fringe of your own industry, that are giving you guys a black eye, that are competing with you in ways that are probably hurting your own bottom line because they're not lying, cheating, and stealing for any reason other than to take customers. And so these are the people that we're targeting, and most of our enforcement actions get brought against. That's supposed to show you that we work a lot with other federal partners, and we do. The mobile printing case is probably the best example. My former office, the Maryland AG's, along with several other AG's offices, led a 50-state investigation of the 4 largest mobile carriers because we found that third-party businesses were just lumping services that consumers never authorized or wanted through billing aggregators onto AT&T, Sprint, Verizon, and T-Mobile's bills. And so we worked real hard with the FCC, the FTC, and the CFPB to work out a better system. And each of these carriers are now under an injunction that requires them to do more to get authorization from consumers before these services can be billed. When we join other states and multi-states, that's our very complicated organizational structure. I mean, we have a couple of states that are leading. Currently, we are leading the formation of an investigation into the Equifax data breach. There are usually executive committees, which will be another larger number of states, usually about 6 to 8, and then the states that can participate. And depending on where you are in that pyramid, you either work harder or do less, but all of the AGs work and coordinate. Consumer protection issues, generally speaking, are nonpartisan issues in AG's offices, and so on that side, we work very well together. These are the different work groups that exist under the auspices of NAG. There are others, these are the major ones. Recently, the autos work group announced a settlement with GM concerning signature of the ignition switch problems. There are always debt relief, debt collection cases that are brought. Health fraud focuses a lot on the marketing of dietary supplements and off-label promotion of pharmaceuticals, privacy. My former office led a very large investigation of Google concerning misleading statements it made about its privacy statements, and then my current office, the District of Columbia AG's office, settled about a month ago a data breach case that had, I think, 37 states involved with the nationwide mutual insurance company. It had failed to apply a critical patch to keep its software up to date and lost about 1.27 million files that had very, very sensitive data in it. And then there's the telecom work group. Oregon, this is probably the most prominent state in that work group. I'll tell you, I know that the focus of this conference is the TCPA and robocalling. Most of those prosecutions are usually done locally. In my experience, I've prosecuted really 2 kinds of cases. Either do not call violations, which is usually some home improvement contractor that just doesn't want to follow the rules and is calling anybody willy-nilly, or it would be TCPA violations where the businesses don't identify themselves. I prosecuted a case all the way up to the 4th Circuit, which is the level before you get to the Supreme Court a couple of years ago, with a political ad where they were calling African-American voters in Baltimore, in Maryland, and Prince George's County on Election Day, telling folks, it was a Republican ad telling Democrats they didn't need to go vote because they'd won, and the political operative didn't identify himself, because if he did, then the ad wouldn't have worked. And it actually was very successful in suppressing the vote, but he still lost. These are some of the issues I've mentioned. I'll go through it briefly. I did want to talk about two local examples of advertising. So let me buzz through this. Well, first of all, developed by the Federal Trade Commission, and it's been adopted by several states. You have to be able to substantiate the claims you make is true, and the level of substantiation goes up or down depending on the nature of the claim you're making. Years ago, I prosecuted a company that was selling aloe vera as a cure for cancer. They were charging $16,000 for treatment, and they promised consumers that they could cure cancer and AIDS. And ultimately, that case went up to Maryland's highest court, and they were required to produce at least 2 adequate, well-controlled studies to prove what they're saying was true. Of course, it wasn't, and they couldn't. You have to disclose material facts, and of course, you can't be deceptive. Okay, so I don't know if you can see this or not. I brought this as an example of a deceptive ad because it's something that my AG cares a lot about. We've been focusing on the sharing economy. The sharing economy is this whole new economy that's being developed on the internet without a whole lot of rules that have been developed. This particular case was a site called Handy.com. On Handy.com, if you live here in the district and you wanted to sell services much like an Uber driver, you could sign up and you could be a house cleaner. And their platform would allow you to offer your services to consumers. And so embedded within that site is actually a very important representation that they made to their consumers, which is that you could trust your cleaner. And this case actually got our attention when I was speaking at a conference, and I had known we'd gotten some complaints against Handy, and a police officer walked up to me and said, "You got to do something about Handy.com." I said, "Why?" I said, "Because they had, in the last 12 months, something like 80 felony reports." Now, I said that we're bigger than Wyoming and Vermont, but they're not all that big, neither are we. 80 complaints in a city of this size is a lot, and we always assume that those complaints are just the tip of the iceberg. We investigated, and it turned out that they were sending people, they had homeless people with long felony histories. And that's not to say, DC has a ban the box law, it's not to say you can't hire felons and send them into people's homes, but you can't do so and tell people that they're trusted and that you check their backgrounds when you haven't. So that case settled, they were returning a lot of money, and they're doing a better job of checking people's backgrounds. The next example I want to give, and this is video. We've all heard about the VW case. VW, for those that have been living in a cave for the last 2 years, VW had installed a defeat device in its vehicles so that when they were tested by emissions officials in states, they would actually work the way they were advertised. The problem was, when you drove them everywhere else, they didn't work the way they were advertised. And so clearly there was an environmental concern because these things are belching, emissions that violated just about everybody's federal and state laws. I worked on the consumer side, and the issue that we had on the consumer side was that they were advertising their vehicles. And so I want to show you a couple of ads, and then I'll ask you what they were emphasizing, which I'll tell you, they denied and denied and denied until they settled. So this is the first ad.
How do you like my new car? Isn't diesel dirty?
I'm saying it's beautiful, for Christ's sake.
I think it's beautiful, but aren't diesels dirty?
Yeah, that's true.
Oh, that used to be dirty. This is 2015.
No. Listen to me, Cherry. Diesel in Latin means dirty.
I'll prove it to you.
You're gonna ruin this car.
Oh, look what you do. See how clean it is?
It's not dirty, but you still have a dirty mind.
So VW, all the way up to its executive level, denied that they were advertising that their cars were clean. And we felt otherwise. We played that ad, and then we also, just for good measure, showed these ads. And so there's no question that they're advertising these cars as clean. We've settled. They're have now paid, I think, close to $12 billion to settle the consumer side and the environmental side. But this is just an example of advertising that we see on a national level and local that gets the AG's attention. Thank you.
Thank you, guys. I have a question, and this one a little bit in my own self-interest, if we can say that, and Pace's self-interest. We have a self-regulatory organization, and it's a very vigorous self-regulatory organization, including standards that require you to comply with the law, best practices. Self-audit is included, and then an independent third party, and then board approval of those. And I'm curious, and Phil, maybe more to you, but like I appreciate your input too, about how you view self-regulatory organizations.
So we view self-regulatory agencies or programs within associations to be a good thing. I'm going to start though from 35,000 feet and say it's always good to have develop a relationship with your AG, to know who your AG is, to keep lines of communication open. And one of those lines of communication should always be we're trying to fix problems. And so, it's not our job to play gotcha when a problem exists. If a problem exists and it's being ignored, or even worse, it's being promoted, then it's a problem for us. But if a business engages in legitimate business and happens to stumble, the AGs aren't going to jump all over you if you're going to try and fix it for yourself. And so from that regard, truth be told, most of the contacts we have are people that come in and say, hey, we have this problem, here's what we're doing to fix it. And that usually will address the problem. That type of a case usually doesn't get any further. And so it's good to keep those lines of communication open. It's good to try and fix problems yourself. And, we support it.
And I would add that that's another example of just meeting your consumer protection attorney general division chief in your state. Develop that relationship so you can go to them if you believe that they can help where there's an issue, you're receiving complaints, they're receiving complaints. This is where the relationship aspect can come into play.
Something that you said, Phil, that I thought was interesting, and it seems when I talk to clients about this, they're always shocked by the fact that when an attorney general says that they have 80 complaints, you consider that there are probably about 80,000 people that didn't complain from those 8,000. Is that accurate as far as perception goes?
It's certainly true. I mean, one of the, I can't mention a case, but right now I'm litigating a case involving a disclosure issue, and the business keeps telling us, well, you don't have any complaints, you don't have any complaints. And we keep saying, well, it's because people didn't know. And it's a disclosure issue. People didn't know they were being taken advantage of. But it's true. And, I went to work for the Maryland AG's Office of Consumer Protection 20 years ago. And I'd say 20 years ago and 2 months was when I learned that the Maryland Attorney General's Office had a Consumer Protection Division. We're not as well known as the Better Business Bureau, and quite frankly, even with the BBB, the number of complaints the BBB typically receives is just the tip of the iceberg. On the other hand, I also want to point out that just because the consumer complains doesn't mean that what they're saying is actually true, correct, or right. Oftentimes we'll get a complaint from a business against a business, and if it entails something that could be significant, but we've got our doubts about whether or not the consumer's telling us everything, we're not going to fire off a subpoena. What we typically do is make a phone call or write a letter. Sometimes it turns out the consumer's right, and sometimes the consumer may be wrong. But the consumer complaints we receive are not the be-all, end-all. And quite frankly, under our statutes, and I think this is true under many of the state's statutes, this is another misperception when it comes to consumer complaints, we don't need them. We don't need a complaint to commence an investigation. That Alavera case I mentioned happened about 12 years ago when somebody from the Tennessee Food Drug Office in the state of Tennessee called up and said, what is this stuff? The guy was selling it out of Baltimore and we didn't have any complaints, and obviously it was a very serious case.
Do you have any other questions?
You guys were so good. Blake, a question for you, and I think this might be of some interest to the folks in this room. If we wanted to present an issue, say call blocking and enabling, to the consumer protection staffs at one of the NAG meetings, is there an opportunity to do those types of things, to present a presentation? Maybe a company has an issue that would be of particular interest to them that they'd like to educate the AGs on?
Absolutely, and we welcome input in that vein. Please contact me, and we will work with you on making that happen.
Typically when we present on issues at our conferences, we try to be balanced, and we have folks from industry, folks as advocates, and folks from our offices. But I understand that the Telephone Consumer Protection Act is a big issue. Obviously our constituents, our consumers are complaining in very large numbers about either imposter calls or the calls that they get at night that they don't want. Michele and I have been talking, and we understand that you have significant concerns about hard-edged rules that allow calls to be blocked in a way that can damage your business concerns. The only thing I can suggest to you is I would encourage you to be very active in commenting on the solution and talking to your state AGs and talking to the Federal Communications Commission to let us know. First of all, the law of unintended consequences is always something you have to be aware of whether you're drafting federal or state legislation. And second of all, your perspective, I can only speak for my office, but your perspective will always be heard.
No questions, huh? Oh, there we go. Rich, I know you counted in.
So, in the news with the Trump election, there was some news about attorneys general stepping up and saying, we will fill any regulatory void created at the federal level with state enforcement. I'm just curious how, kind of get both of your takes on that, on what you've seen change. Obviously, there's still limited resources at the state level of how many things you can pursue, but how's that changed in the last year?
Well, first, let me say from the outset that NAG is a nonpartisan organization, and we represent all of our members, Republican and Democrat, with the same spirit and vigor. And I would not be appropriate for me to comment on that question.
Well, I can give an opinion, but it's mine, it's not my office's. It's interesting. I had a conversation with a friend of mine in a large, very conservative state about devoting resources towards a complex issue we're looking at. And what I was told was that they had a room full of lawyers that used to handle all their complex litigation, which consisted entirely of them suing the Obama administration all the time. And now they've got nothing to do. So they're going to take those lawyers and hopefully put them to a different use. We don't have that in my office, but I'll tell you that we have been involved in some federal litigation out of some legitimate concerns we have about some of the positions that have been adopted now by federal agencies. And I'll give you two examples. The first is we were very heavily involved in regulating for-profit schools. The concern is that a lot of these for-profit schools were overpromising in education to people that, quite frankly, couldn't have any real meaningful opportunity to complete that education. Folks are getting enrolled who were illiterate into programs that they couldn't complete. There were problems with their advertising, what was considered a successful graduation, what was considered a successful career placement. And the Department of Education passed a borrower defense rule and other rules that allowed the students who had been victims of fraud to get relief from the federal student loans. AGs were recruited and asked to help get the word out, which we did. And now under the new the new administration, those rules are being rolled back, and the very same consumers that were promised relief and told they could stop paying their loans are not getting relief. How those rules are being rolled back are in ways that we believe are illegal, and now we have filed suit against the Secretary and the Department of Education. First and foremost, to make sure if these rules are going to be rolled back, they've done so in a way that's open, transparent, and legal. Second, we think these rules were passed for good reasons, and we would like them to remain. My office actually filed a fairly high-profile suit about a month ago, along with the Maryland Attorney General's office, to enforce the emoluments clause of the U.S. Constitution. The concern is that the President's businesses here in the city are harming other businesses in the city in ways that the Constitution doesn't permit. The second way I'll respond to your question is that there are always going to be enforcement priorities that will ebb and flow. And it's not just with the change of administration federally. I mean, administrations come and go on the state level too. And so, yes, we're trying to prosecute cases that we think that the federal government may be less vigorous. We're looking at some of the things that the CFPB has traditionally looked at to see if the CFPB as presently constituted is going to remain. We've been intervening, filing motions to get involved in federal lawsuits that other federal agencies are currently prosecuting so that we can make sure that those cases will be continued to be prosecuted. Sorry, it was a fairly long answer, but we're fairly active to try and make sure that the enforcement priorities that currently exist remain priorities.
We finished right on time, so I see that there are some other questions. Do you guys mind staying?
Sure.
Meet out in the hall if you have some additional questions. So thank you both so much for participating today. We appreciate it.
Thank you.